The High Court in Pietermaritzburg has dismissed the private prosecution brought by former President Jacob Zuma against prosecutor advocate Billy Downer and News24 journalist Karyn Maughan. We're joined now by legal analyst Mpumelelo Zikalala and Pieter the Toit, who's the assistant editor at News24, just to get some clarity around this. Very good morning to you. Thank you so much for joining us, together with Mpumelelo Zikalala, who's out in the field there to give us reaction. But before we go out there, Pieter, this must be a massive win when it comes to media freedom and the precedent that it sets.
Absolutely, and Paul, at News24 we're very pleased with the court's judgment this morning. We still haven't yet received the full judgment, but as far as the order is concerned, I think it's very clear that the court saw this attempt by the former president to privately prosecute a state advocate as well as a journalist as frivolous. So we're very happy. I think it's a strong defense of press freedom, of freedom of speech, freedom of the media. News24 stood by Karyn, our senior legal reporter, from the beginning, and we're very happy that the High Court vindicated the arguments that we brought in court.
Mpumelelo, what's your take? I mean, does this mean that this matter is done and dusted, or, should it continue if former President Jacob Zuma decides to appeal the ruling?
Good morning to you. There's still that option, because what it basically says is that he can come back here and say, can you please give me leave to appeal to the SAA? I believe that another court may come to a different conclusion based on the facts and what I've read in the 58-page judgment. I think there's something that they might have missed in the determination or interpretation of what the law actually says. So once that has occurred, then you may see the reinstitution of these particular proceedings or the reactivation of the summons being live summons. It doesn't mean that anything is going to continue while that particular adjudication or the matters hasn't been done and dusted within the SAA or even the Court if they so wish to go there. But it definitely is an option which is available to the former president in terms of saying, I believe the SAA will come to a different conclusion, grant me leave to appeal to go there so that I can be able to argue my matter at the SAA.
And how strong a case would that be, looking at the merits of this case and how it's panned out?
I must confess that I haven't looked at the 58-page judgment. I've simply glanced over it. But there are certain pertinent matters that have been discussed in the judgment. The first one is that of urgency, saying that, yes, the matter is urgent, and the determination that it must be heard on an urgent basis. I think that's not much of a headache, but what needs to be looked at more is the determination of what does it mean to have an early prosecutor certificate. Does it, and the modalities in which that type of certificate ought to have, like a specific name, for example. You remember that the certificate which is currently out there only applies to advocate Billy Downer, who's been specifically named. So you have a tailor-made non-prosecutor certificate against him, but not against Ms. Karyn Maughan. Then the question is, do you include any other person that is there? Let me determine and interpret how that ought to have been made, and how do I go about in terms of instituting this type of proceedings. You must also remember that in South Africa we haven't had that many private prosecutions that have taken place. So it is new territory in terms of our legal jurisprudence. It needs to be developed now and again, just to make sure that we are doing things right in line with the Constitution. And there are going to be impediments such as these ones. And there are going to be times in which you would need the court to step in once and again or time and again in order to determine which is the correct process and avenue that one needs to follow when there's a private prosecution which is involved. And not leaving behind, by the way, the right by the media to be able to report on certain matters. When does it end and when does it start? And when does it start to be an infringement and when does it start to be a media personnel simply exercising their job and sticking to what the Constitution actually states in terms of protecting their right or protection or freedom of the media to report on certain matters.
Let's perhaps come back to studio. I mean, I see you reacting as Mpumelelo speaks about the media and how important this case perhaps is in terms of the messaging it sends out to former President Jacob Zuma.
Yeah, look, I think the message from this court is very clear. It was an attempt to bully and intimidate a journalist, and it was an attempt to undermine the rule of law by attacking a state advocate based on spurious allegations and spurious charges. I mean, the court's very clear. I mean, the former president has now been slapped with the most serious cost order that you can get in a high court like this. It was a full judgment. 3 judges of the High Court agreed that this was a frivolous attempt to try and subvert the rule of law. And I think that should be the focus. I mean, this president has, over the years, used every single legal trick in the book to try and stay out of court. He's now gone a route that no one has ever gone before by trying to remove a state prosecutor, by trying to attack a journalist. Now, this is a country that's based on the rule of law and the rule of the Constitution. And I mean, the public's interest in this is massive. So Karyn Maughan never in any way, shape or form broke the law. She was given documents that were lodged in the High Court, and that's what the court now found. That should be the focus. This former president has abused court process over the years, and that's what the court said now. It sent a very clear message not only to former President Zuma, but to his advocate, Advocate Dali Mpofu, who never seems to win any single case that he takes to the High Court. And I think serious questions needs to be asked of him. What kind of advice does he provide his client with? Because he always goes to court and loses. So I think the focus should be on the attack on press freedom. The focus should be on the attack on the rule of law that Mr. Zuma precipitated, and on the strong order that was handed down by the High Court, which said no more, and Mr. Zuma has abused the court process, and he's now been slapped with a severe cost order. That should be the focus.
Yeah. Mpumelelo, what's your take on that? I mean, on the outcome of this matter? And of course, the essence, revolved around contravening the NPA Act in that Downer had leaked this confidential medical records to Karyn Maughan.
I think I wouldn't be doing any justice to that type of analysis because I haven't gone through the judgment in terms of the determination on what the court looked at. But the most salient ones is, we must also remember that courts are there to resolve disputes. If there were no disputes and there was harmony in terms of the interpretation of certain provisions that are there, we don't even need the courts to adjudicate on our matters. So going to court and exercising one's right is something which is available to any other individual that is there. And if you choose to go the instructions of your client, that's basically what you have, and you simply go there as a legal practitioner to go and present the strongest case that you can have, and the only decision that you can wait for is, as it has happened now, as to what the court actually states. So we need to go to the judgment, look at it, and then understand where the court was coming from. But what is important is that what the court has lamented today is that yes, there's right to media freedom. As to whether there are any limits to that, is something in which we would need to get at a later stage, including the manner in which the SCA or the Criminal Procedure Act is then being interpreted.
And in terms of the messaging and how the court swayed, what do you think stands out as a matter of significance in this outcome?
The court basically is saying when it comes to certain individuals or all individuals that are citizens of South Africa, we are going to protect your rights no matter what. Even if there's another court which is about to distribute or adjudicate on your matter, once it involves your human rights or the rights which are entrenched in Chapter 2 of our Constitution, we are going to step in as a civil court and be able to determine the accuracy or the correctness or the lawfulness of whatever action which is being taken against you. It means that doors of the court are open. Any other disputes that are there may be taken to the court. It may set a precedent, though, of saying that whenever people are being prosecuted, whether in a private prosecution or a normal prosecution, they'll then go to the civil court and then state, show me the reasons in which why I'm being prosecuted in this manner. I need to establish that there's a plausible prima facie evidence that I need to go and answer in the criminal court before I go there. Some may view that as being a long process or a process that could only be discussed in a criminal court being discussed in a civil court, but some may view it as a process of saying if the courts are there to adjudicate on matters, access to courts as entrenched in our Constitution is exactly what is happening. If I feel aggrieved by any action that has been taken by anyone, I should be able to go to court and be able to protect my rights, and as Advocate Billy Downer and Ms. Karyn Maughan have done.
Very well. And Mpumelelo, Zikalala, we'll perhaps leave it there for now, getting some reaction to that. And very lastly, before we let you go, I mean, you say it's a win for media freedom, and of course, perhaps what do you think it sets in terms of a precedent for journalists when going out there and reporting stories? How does this case validate the work of journalists?
Well, I don't think it sets a precedent. I mean, Karyn operated as a journalist is supposed to. So it's merely defended the right that we have to report on court proceedings and events in the public interest as we used to do. So this was an attempt by Jacob Zuma to set a precedent. This was an attempt by Jacob Zuma to try and subvert what we do in the public interest. So this merely affirms and confirms what we are allowed to do as journalists. We've always been very clear in that that we act within the bounds of the law, the Constitution, and the press code. Mr. Zuma has tried to not only subvert the rule of law by attacking Billy Downer, but by attacking the freedom of the press and freedom of the media. So this is confirmation of what we do. This won't set a precedent as such. It just confirms that we know what we do, that we will continue down this path, and we will certainly not stop in investigating and writing about Jacob Zuma. His court case, his corruption case, is supposed to go ahead on the 15th and 16th of August. Let's hope that he sits in the dock and can answer the tough questions, which he has refused to do for 18 years this year.
Yeah, absolutely. Thank you so much, Pieter Toit, the assistant editor at News24, just speaking to the breaking news just in.